Okay, so what happens to our hero is they got their summary judgment. And when they got their summary judgment, there was an 8-page summary judgment order issued. Okay? So this is, in relatively speaking, this is a long son of a gun. Okay? It wasn't a marginal entry that said that the United States won and they're going to collect their debt. It's a long son of a gun. And it's so incredible what is and is not being said in this summary judgment that I asked my friend if it'd be okay if I'd be able to read it for you people on tape, and he said, no problem. So this is fresh out of the United States court within the last week. Order. This case comes before the court on the following 6 points. 6 is what? The number of man. This is based on man and sin. This case comes before the court on the following. 1, motion by the United States for summary judgment. Document 124. 12 and 4, perfect government for things of this world. Number 2, memorandum of law in support of the United States motion for summary judgment. Document 125, dealing with forgiveness of sins, 25 times 5, and grace. Number 3, notice of appearance and return of a Milborn order. 4, acceptance of motion by the United States for summary judgment for settlement and closure. Document 128. So, in things of the world, the 4th point, part of the reason that this order is going down is because our hero accepted it and returned it. 128. 28 deals with live forever, or 12 and 8, perfect government, new beginning. Number 5, a precipice for mandatory judicial notice of House Joint Resolution 192 of June 5th, 1933, and tender for settlement and closure. Document number 129. 12 is perfect government. 9 is judgment. Notice that's the 5th point, which is grace. Basically, he's saying, take notice of your insurance policy not to have to pay and the fact that I've already permitted tender. And 6, a bond for acceptance of motion by the United States for summary judgment, specific surety bond or security bond for subrogation. Document number 130. 30 is the blood of Christ that pays the price of sin. Background. Do you think the court's got a good basis for going ahead with their judgment here? I think they're really saying we got agreement of all the parties and we got all the important information right in front of us. What part don't you understand that the court doesn't understand? Okay? Background. On August 19, 2002, the United States filed a complaint against our hero for unpaid federal taxes for 94 and 95. The United States also stated that it would seek interest in statutory penalties. The trust was named as defendant because the United States claimed it is the alter ego of the straw man. No, they don't say straw man in here. And was created by him only to conceal assets that may have to be liquidated to discharge the tax debt. Okay, hang on. What did I just tell you? I said, why is it that they might want to go after the assets of third-party creditors? You're dealing with a debtor who's hiding assets belonging to the true creditor. So what did the person that wrote this document for the court just say? Just exactly what I told you about 15 minutes ago. They understand what's going on. The history of this case is difficult to summarize because the defendant has steadfastly refused to participate in a constructive way. which is like to say, this is all a lie, it's in reverse, he's been helping us out. His voluminous submissions to the court, what, his acceptance and return, are written in gibberish. Oh, they're too comprehensible for our colorable court to be repeated. He stamps almost everything he receives with a meaningless reference to the Uniform Commercial Code and a certain congressional resolution. And then he returns these stamped pages to the United States and the court under the apparent belief that by doing so, he has miraculously satisfied his tax debt. Using this magic stamp, magic was included by me, it should be noted, seems to be only a precaution for the defendant because he has concluded, by virtue of reasoning comprehensible only to himself, that the United States long ago conceded that no such debt exists. For example, in an affidavit filed at the inception of this case, the defendant stated that his debt was discharged, settled, and his case subject to closure because the United States Marshal who served the summons did not enclose a check with it. Excuse me? I accept it for value, return it for value. I authorize my exemption for settlement and closure by offset and adjustment. And I'm waiting your check. Where's your check? What is the check? The receipt and the title for the payment. So they're putting it backwards, of course. Okay? This sort of bizarre logic, liberated from even the most basic standard of common sense, pervades our defendant's writing and has rendered it all but impossible for the court to understand him. Not this court. The court. Hello. Which court are we speaking out of? Private law court. Your first clue. Thanks, Bob. Standard of review. Summary judgment is authorized, quote, if the pleadings, depositions, answers to interrogatories, and admissions on file, together with the affidavits, if any, show that there is no genuine issue as to any material fact, and that the moving party is entitled to a judgment as a matter of law, unquote. See Federal Rule of Civil Procedure 56C. Has the United States most likely indeed put any facts of a charge in their charging complaint? None. So what fact is it that's before the court? There's no facts. All there is assumptions and presumptions and procedures of honor. There are no facts. There's no truth. There's no reality in the bankrupt public system. And only the public has spoken. All he did was accept. So there are no facts. See, we're spinning our wheels about nothing. Oh, all those facts are here now. We're going to give you an order. Summary judgment is appropriate only in circumstances where, quote, the evidence is such that a reasonable jury could not return a verdict for the non-moving party, unquote. The moving party bears the burden of proving that no genuine issue of material fact exists. How can the United States, the moving party, prove that there is even a fact that exists, let alone proving that a burden of no genuine issue of material fact exists? There is no facts at all. There was no disagreement to the non-facts, so they can't prove that there is an argument going on to the facts. And if there's no argument going on to facts which aren't even present and don't exist, and our party never argued with those which don't exist, then doesn't the court assume it can go forward with the summary judgment? Absolutely. They're absolutely right. Because there are no facts. The whole thing is an illusion. The only time the illusion becomes real is when the patriot gets in there and starts arguing facts. Then the illusion becomes real and they lose every time because of their argument. Next paragraph. In determining whether the moving party has satisfied the burden, when they've presented no facts and there's no argument as to the facts, the court considers all inferences drawn from the underlying facts, which don't exist because there were no inferences, because there was no objections to facts that were never there, in the light most favorable to the party opposing the motion, which means the reverse. We're going to screw the guy if he argued facts that aren't there. And resolves all reasonable doubts against the moving party. The court may not weigh conflicting evidence. We don't have evidence, and we certainly don't have any conflicting evidence here. Or weigh the credibility of the parties. Oh, so whether you're sane or insane, or they allege you're insane, is irrelevant. That's good. They can call you whatever names and send you to the psychiatrist as many times as they want. And that's not the criteria for the judgment. You see how they're telling you how they play the game? See Hairston versus Gainesville Sun Publishing Company, 9F 3rd, 913, 11th Circuit Court, 1993. If a reasonable fact finder could draw more than one inference from the facts, and remember, there are no facts in any of these cases, unless, of course, you're a lunatic, and that inference creates an issue of material fact, the inference because of your inference to something that doesn't exist, then a court must not grant summary judgment. Analysis. Notice how they told you what's going on, but it's all backwards. As a preliminary matter, the defendant has not filed a memorandum in opposition to summary judgment in a form consistent with Local Rule 3.01 subpart B. What's that mean? He won't argue with us. That's good. Because there's nothing to argue about because there's no real facts here. He did, however, file several documents, which the court will collectively treat as his response. Which is like saying, okay, it doesn't come under the rules, so you done good, my brother. In its motion, the United States seeks to reduce to judgment the income tax liabilities against the defendant and to foreclose federal liens arising out of these liabilities on real property held by the defendant trust. Citing Exhibits 2 and 3 of its memorandum in support of summary judgment, the United States represents that the defendant's tax liability is $60,306.27, excluding interest and penalties. The United States contends that there is no material dispute as to this sum because, one, federal tax assessments are presumptively correct. So we don't have to prove it. We're going to presume it and create a mammoth illusion to see if you will bow down and worship it by arguing. And two, the defendant does not dispute this. He doesn't want to argue with an illusion, both of which are true. Has this court lied in anything it's said so far? This court is doing everything perfect, but colorably. Just exactly like we've been teaching it. Gets better. The United States is, of course, correct. Federal tax assessments are presumptively accurate accounting of a taxpayer's liability. See Bone versus Commissioner, 324 F. 3rd, 1285. Must have been a case somebody argued and lost. When a taxpayer contests a tax assessment, the burden falls upon the taxpayer to set forth why the assessment's wrong. How are you going to do that to prove an illusion is wrong? how can you prove an illusion which can't exist is wrong? So by trying to prove it's wrong, you've made it good. Which is why all the tax protesters' arguments, no matter how logical and how much founded on research, is bound to failure because their logic fails, not their argument. The defendant does not appear to contest the accuracy of this assessment. Good finding. As the United States points out, the defendant's failure to respond to the government's request for admission constitutes an implicit admission of everything alleged in the request. There you go. He's great. Man, they're just saying up and down, number one, he didn't argue. Number two, he really didn't argue. So number three, our hero is not in dishonor and he's not losing. Okay? The Federal Rules of Civil Procedure 36A, United States versus 2204, Barbara Lane, 960, F. 2nd, 126, which is a 1992 11th Circuit case. Furthermore, the defendant has throughout this litigation continuously repeated his mantra that there is no dispute concerning the facts of this case. Third time they've said this is exactly what our hero is doing. The undersigned defendant this is a quote, the undersigned defendant does not see, defendants in parentheses, does not see where closure of this matter and honor has not been sought from the outside of this action, unquote. Now, not only have they said it 3 times by conclusion, they've quoted our hero as saying the same thing. 4 times. Things of the world. Done right. In docket number 86, document, the defendant's motion for summary judgment, the defendants do not see a controversy before this court in that there are no disputes with the facts of this case, unquote. 5th time that we're agreeing. Therefore, the only question at this juncture, this court order says, is whether the various documents the defendant filed in response to the United States motion raise any issue that ought to preclude summary judgment. Gosh, I hope there aren't any. We've been looking forward to it. Once again, the defendant's submission to the courts are indecipherable. That must mean good stuff. Because if the public, which is everything colorable, can't see them, they must be from a foreign land and they must be good. Otherwise, the public would take those documents as a dishonor and we'd be in a heap big trouble, wouldn't we? Document 128 begins with 4 paragraphs of vacuous, pseudo-legal nonsense and concludes with 10 enumerated paragraphs in which the defendant purports to repent before the court for 10 instances of dishonor. Boy, it really upset him now that he's asking for forgiveness. Indefatigable to the end, the defendant also appends to document 128 a copy of the government's motion of summary judgment with each page imprinted with what must now be the defendant's well-worn yet always faithful UCC stamp. Nothing in document 128 precludes summary judgment. Whew, we overcame that test. We don't want to stop a train that's rolling in our favor. Document 129 is a demand, one the defendant has made before, that the court take notice of House Joint Resolution 192. The defendant cites, without explanation or excerpt from this document, which, as best as this court can ascertain, involves the suspension of the gold standard in 1933 during what Congress characterized as, quote, the existing emergency, unquote, in parentheses, the Great Depression, presumably. The defendant appears to believe that this passage extinguishes all debts, past, present, and future, between the United States and any other person or entity, including himself. The meritlessness of this argument is obvious, which is a perfect mirror. His logic is absolutely correct, brilliant. See Crane versus Commissioner. 737 F. Second, which stating that courts are not obligated to respond to the frivolous arguments of vexatious litigants. That's in parentheses. Are they claiming that our defendant is a vexatious litigant with frivolous arguments? No, it's in parentheses. It's not there. But the guy that argued it went down in flames. Just go to that court case. You see? You understand when you get to the level that we're seeing these at, these people are coming back in spades and they're ratifying everything we're saying. It's absolutely incredible. Nothing in document 129 precludes summary judgment. Whew, overcame that test. We didn't shoot ourselves in the foot in that one either. There you go. Bring it on, baby. Finally, document 130, heavily salted as usual with the defendant's inimitable use of language. Parentheses. For example, titling this submission, quote, specific surety bond for under subrogation, unquote. It's not there. Seems to be a declaration by the defendant that he plans to pay his tax debt. I left something out. That he plans to pay, comma, or perhaps has paid, comma, his tax debt. What'd the court just say? Is the court charging him with his instrument being no good? No. No. Do you understand what this court is doing here? It gets better. He attached to this document photocopies of what may, parentheses, or may not, parentheses, be wire transfers made through the Federal Reserve System. They may be wire transfers, may not be, isn't in this document. Given his penchant for claiming that he has satisfied his tax debt, let's go back to that. That he has done wire transfers, parentheses, or may not, unparentheses. Why did they do it that way, even in a public document, rather than the other way around? No, you're missing the point. In a public document, why did they not say that he's not done a transfer, or possibly it may have? Why didn't they do that? That would have been better to the public. Or may not is in brackets rather than or may is in brackets. I'm saying, why did they do it the way they did it and not the other way around, which would have been better for the public? They don't want to charge him with not paying. Because to charge him in a document which Bob says came out of the private court, the court, would have been charging your brother. See, if we have a civil complaint with no facts in it, and the whole thing is an illusion, and our hero has been in true honor, why would they come back and charge him with anything at this time? There is nothing in this order charging our hero with anything wrong. In fact, it puts the best construction on everything and assumes he's done everything right, except by the innuendo. You understand? given his pension for claiming that he has satisfied his tax debt and his citation in document 129 to House Joint Resolution 132, it should be 192, the court is skeptical, to say the least, that the defendant has done what is necessary to discharge his debt to the United States. This order find that he didn't do it? No, they're just skeptical. And they're not charging him with not doing it. There you go. Didn't say he did, didn't say he didn't. That's my story, and I'm sticking to it. It's just nothing. It's just an illusion. Just like our court case was an illusion. This is just a big illusion. The defendant has done what is necessary to discharge his case. In other words, document 130 is either one of the defendant's usual tricks, or it is evidence that he is trying to pay what he owes. In any case, nothing about document 130 precludes summary judgment. We're doing okay. Next paragraph. Summary judgment for the government is appropriate. Upon review of the record, the court makes the following findings of law and conclusion of law. Okay, they're going to make findings of fact, conclusion of law. How many times you ever see that in most of these equity courts? Nothing. We're not in an equity court anymore. We're in a private court of law, right, Bob? We'll get a second witness to that in a little while. Okay? Now, it says summary judgment for the government is appropriate. What are they really saying? No, summary judgment for the defendant is warranted. It's backwards. He's the one that asked for settlement and closure. Government can't ask for anything. They are debtor. You understand? There you go. Okay, now, in the findings of fact and conclusion of law, there are 7 paragraphs. What's 7? It's completion, yeah. Masculine completion. Is a law court masculine or feminine? Masculine. Equity court is feminine. Okay? So this is a second witness that we're in a law court. There's 7 findings of fact, conclusion of law. Number 1. As of September 1st, 2003, the defendant is indebted to the United States for unpaid tax liabilities for the year 1994-1995 in the amount of $60,306.27. He also owes any interest that accrues on this amount between September 1st, 2003 and the date of payment. Did it say he didn't pay? Didn't say he did, didn't say he did. Okay, with this judgment, number 1, with this judgment, do we now have a ratified debt? Yes. Absolutely, that's what he's looking for. Number 2. The defendant is specifically instructed that when the court stated in the preceding paragraph that the defendant is indebted to the United States, the court means the name of the person. But this guy's name is upper and lowercase, but it's got upper and lowercase, the person. What is that? Upper and lowercase, the person. But an upper and lowercase is not a person. So when they say upper and lowercase, the person, they're saying the all capital letter name. Because the only entity that's a person is an artificial entity. Okay? But they put it in here in upper and lower case to make it look like all these patriot arguments are stupid. Okay? They didn't say upper and lower case the living soul. There you go. The court, in other words, does not mean upper and lower case in, quote, mirror image, unquote, which means they do mean that, or the upper and lower case name with the copyright symbol. Remember all these people under the Book 3 doing copyrights? Or any fictitious version of the upper and lower case name, such as a trust, So what they're trying to do is get you to argue that all these realities are not true. But they're saying that what we mean is the person. They don't have to go any farther. Who is the person? The straw man. Yeah, the people are not the person. The person is the artificial name. Go ahead.
Or that the straw man is there.
Absolutely. The straw man is the person. It's the corporation. And what they're really saying is we don't mean the trust. Why didn't they mean the trust? It's an alter ego. We can't see it. We're not after that foreign person. We're just after all of the stolen goods you tried to give to them. And we don't mean the living man, and we don't mean anything you tried to do by copywriting him. And we don't mean anything you're trying to argue. All we're looking for is what we control, which is the person. It's all about what they control. The only thing they control is the straw man name. Everything else, argue away. We don't care. And why did they put this number 2 paragraph in here? No. 2 deals with division. They're trying to get you to come back and argue that it doesn't apply to me. They're still trying to get you to argue something by raising an issue which you tried to put into your paperwork to see if you'll come back and argue it. If you argue a judgment in your favor, you've dishonored the judgment and you've now lost. We'll take that back and execute it on the public side. They test you completely to the end, okay? Number 3, this deals with the church. The trust is the nominee or alter ego of the upper and lower case, and was created for the purpose of concealing assets needed to discharge a lawful tax debt to the United States. Okay, now that's colorable. For a lawful tax debt, there is no law. Okay? Debtor, the United States a debtor, they couldn't collect anything except on your dishonor anyway. Okay, so they threw that out. But they're telling you the reality of the truth, that the unregistered trust you created is a third party concealing assets that the true creditor to the United States, the states, and the created entities of the persons owe a liability, and that's why we're coming after it. They just told you the truth again. And it's in number 3. They're the church. The black robe people told you the reality of what's going on here. They told you the truth. 4, things of the world. As a result of this debt, not the debt, this debt, it's a fiction. The United States has a valid lien against all property and all rights of such property belonging to the defendant and the trust, including but not limited to the real property of such and such a location, for a precise, look to a document for a precise description of the subject property. Okay? Number 5, grace. So what, on the number 4, they're claiming a claim on property. 4 is things of the world. What has the kingdoms of this world done to God's creation? They've divvied up the land into what they have ascribed to be property. Property is the illusion mirror of land. They're making a claim on the property, not a claim on God's land. So they're staying in their fiction. Okay? So their world, this world, is the property world, and the world is the land world. And they're claiming a lien on the property, not the land. 5. The government is instructed to provide the court with a proposed order of foreclosure and sale. Backwards it's going, I think we're going to settle this, but if you think that there is a dishonor, you can go ahead. 6. The court retains jurisdiction over this case for the purpose of, inter alia, entering a judgment of deficiency if the proceeds of the sale of the real property are insufficient to satisfy the debt. Now hang on. 6, number of man. What they're saying is if this guy comes back and creates a dishonor so his bill of exchange does not have to be processed, then we can retain jurisdiction to proceed for a public execution. The description or what the court said? Repeat again. Both? The court said the court retains jurisdiction over this case, not the case, for the purpose of inter alia, entertaining a judgment of deficiency. Entertaining means if one comes in. If the proceeds of the sale of the real property are insufficient to satisfy the debt. When would the property go to sale? If the debt had not been settled and closed and discharged, paid. The court has made no judgment that his bill of exchange has not in fact done that. Yeah, if the proceeds of the sale, or if the bill of exchange hasn't already prepaid the account. Duh, okay? So the issue is they're retaining judgment so they can go on in a public execution if our hero screws up the private tender of payment by a dishonor. Otherwise, why would they sell a house in a foreclosure if you came down and paid off the debt before the foreclosure sale? Case would be over, be dismissed. So this is perspective, making it appear as though his tender offer of the bill of exchange is not an adequate payment. But before the prosecution can put up a notice of sale of the property, they're going to have to test him to see if he'll dishonor his own bill of exchange. If he dishonors his bill of exchange, then in that dishonor they can ignore it and move toward a public execution, which is a sale of the property. Understand what they're saying and what I'm saying here? You're testing him again. They're going to keep testing him all the way down to the end. Not only that, they're reading a colorable thing here so that when you read this and you have no clue what's going on, you'll say, that bill of exchange is no good. They're going to foreclose on his house. Okay? 7. 7 is the masculine judgment. The defendant has exhausted this or the court's patience. Still a court of law, isn't it? The defendant has exhausted the court's patience. His memoranda may have been turgid, opaque, and all but meaningless. And in a rare moments of lucidity, they argued meritless positions. Now wait a minute, if they were opaque and meaningless, sounds to me like they were colorable, which means it fit right into the court. So there's no dishonor there, so instead of exhausting the court's patience, they must be very proud of this litigant. He's fit right in. His obstreperous approach to this case has wasted the time and resources of everyone involved. Notice that there's been no jury trial, no deposition. At minimal, he's accepted all the paper and returned it, thereby wasting everyone's time and resources by keeping the procedures to a minimum. They didn't make any money. The attorneys are broke. The defendant is to consider himself forewarned or honored. Any further failure to participate in this case in a form consistent with the rules, the requirements of Rule 11, will result in sanctions under that provision in the court's own inherent power. Notice, any further failure to participate, any dishonor by this guy is going to get nailed. I'm warned, man, I don't want to do a dishonor. Oh, I hope I can keep up my best efforts here. Okay? Now, have they said he's been in any dishonor? Have they said that he's argued anything and they can't do the judgment? Everything's the reverse of what they said in paragraph 7. Duh. Conclusion. This is where it gets absolutely incredible. For all the foregoing reasons, the United States motion for summary judgment, document number 124, is granted. Whew, we made it. We got our debt. Judgment shall be entered for plaintiff and against defendants. Oh, I know all the patriots out there are going, what are you, an idiot, Smith? Your guy just lost. Next sentence. The clerk is directed to close this case. This case is on the public side. Last paragraph. Done and ordered in chambers in Florida, this 25th day of October 2003. That is a common law order. Date certain, place certain, in chambers. What's in chambers tell you, Bob? Third time they've told you this is a private case judgment. Can this be quoted? Doesn't apply to anybody except this case. It's a private case, even if it went to appeal. But signed by the Chief United States District Judge of that court. Whoa. This is just some stupid-ass $60,000 civil IRS case. The Chief United States District Judge, not a magistrate, because magistrates don't have judicial power. You understand what's going on here? Now, this guy sends this to me and he goes, oh my God, I don't know, did we do right? Is there anything going right here? And I'm going, cool, man, this looks great to me. I think we won by losing, didn't we? Now I said this instrument's got to be good. Okay, so now the deputy clerk puts out an official-looking document, judgment in a civil case. I don't know. This is a lower court. So, decision by court. This action came before the court. The issues have been heard and a decision has been rendered. It is ordered and adjudged that the judgment is entered in favor of plaintiff and against the United States. United States won again. Go Patriots. Okay, so it's done and done. Now, along with this mailing to our hero came a sheet called the Civil Appeals Checklist. Yeah, you want to argue this? Now, it tells you every way you can go to the appeals court and argue it if you want to. It gives you an assistance. It tells you what you can, what authority you got to come under, the timing for it, how you do it, what you do. Now, remember number 7, it says, any further failure to participate in this case in a form consistent with the requirements of Rule 11. What's Rule 11? Sanctions. But where do the sanctions come under Rule 11? No, not necessarily public. What is the source of allowing a sanction under Rule 11? What's sanctionable? Frivolous conduct not in line with issues of law. Who would want to appeal this judgment? Everything in this judgment is in your favor as an issue of law. They warned you in number 7, if you do, they said any further failure to participate, it's backwards. If you proceed in this case and it violates substantive issues of law, you will be sanctioned. Now, we're going to give you a whole list of possibilities. Would you like to go up on an appeal of a judgment in your favor so that we can nail you under Civil Rule 11, and by sanctioning you, we will take away your win and execute against you in public? Isn't that what they just told him? Another test. It's absolutely perfect, and it's absolutely the mirror image of the public goes on to the private. Now, this guy sends this to me and he goes, gee, did we do a right job? I said, well, what do you want to change? You want to go back and argue non-facts and be in violation so that they can sanction you? You want to go to trial and try to win one for the Gipper? Do you see what that court did? Are you now able to read a colorable judgment and understand by a careful discerning of the words, the numbers, and the way the court explains things, exactly what's going on? This guy did perfect. Now there's going to be people out there that says, but this guy may not be out of the system yet. This guy may still be in commerce.